Wonderful to have this opportunity to talk about the proposed change in consent laws in sexual assault cases. Ladies and gentlemen, the New South Wales government is about to barge through your bedroom doors.
I hope you take notice of that important warning from prominent Sydney barrister Margaret Cunneen. She was speaking at the Presumption of Guilt conference last week, run by the Rule of Law Education Centre. She knows what she's talking about. This is a woman who spent over 30 years at the coalface of the criminal justice system, decades as a Crown prosecutor convicting rapists and other villains, and a commissioner in charge of a large child sex abuse investigation. Now she's back at the bar, successfully defending an endless queue of accused men, including many alleged rapists. Cunneen's presentation focused on the impact of the new sexual consent laws that Attorney General Mark Speakman aims to ram through New South Wales Parliament. 2 years ago, Speakman appointed the New South Wales Law Reform Commission to look at the proposed changes to these laws, but then ignored their warnings about injustice that could result and decided to introduce affirmative consent legislation. This comes after years of concerted feminist lobbying for a yes means yes affirmative consent model where enthusiastic consent must be given throughout the sexual encounter. Now Speakman has proudly announced he's giving the feminists what they want.
We're going one step further than what the Law Reform Commission recommended. To have a reasonable belief, an accused will have to have taken steps. The accused will have to have done something or said something reasonable in the circumstances to ascertain consent.
This means that most of the sex that most of us have could now be illegal, as explained by Margaret Cunneen. Her view was supported by the New South Wales Bar Association, which spoke out strongly against the proposed legislation. But this is simply the latest step in a wave of feminist reforms trying to increase rape conviction rates. The great irony is that the major result of this tilting of our laws to favour complainants is that more weak cases are pushed through to court, which then get tossed out by juries. Margaret Cunneen is now president of the Rule of Law Education Centre. What's really important about her recent online presentation was she exposed the breakdown in the filtering system, which used to ensure that only cases with sufficient evidence went through to trial. Now the police are under orders to see all complainants as victims. They have no choice but to believe these so-called victims, and most rape cases end up in court. Watch Cunneen here exposing what Police Commissioner Nick Fuller's language says about the corruption of the system.
And Commissioner Nick Fuller, Police Commissioner, said the police are committed to supporting victims. As police, our primary rule is to support victims who courageously come forward to police to report sexual assault. This is where we go off the track. There was even, before things used to hit the Office of the Director of Public Prosecutions, police had a filtering process too. They are no longer permitted to do that. I know that they are instructed by the Commissioner now to refer in fact sheets before there is any conviction of any person to any complainant in sexual assault as victims, and of course to treat them accordingly. They have very little discretion or none in proceeding to charge, and yet with ownership of the case, the police then want the case to succeed. But once the complainant has been declared a victim or regarded as a victim, there's not much more investigation that goes on. There's just a zeal to get to the end and to convict the charged person.
Listen to that, people. Our justice system has been taken over by this believe all victims mentality. The police, the public prosecutors have been robbed of their filtering system, which ensures our juries had to decide only cases for which there was proper evidence. And as Cunneen points out, more and more cases are now bound to fail.
The more cases that are run, and the less that the Director of Public Prosecutions engages in any filtering process, the fewer cases will result in conviction. So that if there has been any diminution in recent years, I would contend, because so many cases, so many weak cases that used to be filtered out in the proper operation of the Office of the Director of Public Prosecutions are not being filtered out now.
Earlier in her presentation, Cunneen explained she remembers few rape cases from when she was a Crown prosecutor where they didn't achieve convictions because the weak cases had already been filtered out. It was assumed it was better not to proceed without reasonable evidence. That's all changed. Cunneen says prosecutors no longer tell complainants that their cases aren't strong enough to go to court.
Perhaps prosecutors don't have the stomach for conveying the bad news, but it was always better for a complainant to be told the truth about the strength of the case before it started than to conduct a case which inevitably resulted in a not guilty verdict, and then the complainant goes away feeling as though she or he was not believed.
That's what we're seeing now. More cases failing, complainants feeling let down by the system, and ever more bleating from the feminist lobby about our justice system failing victims. Exactly the same is happening in the UK, New Zealand and Canada as feminist lawyers play the same blame game. Just look at the news from the UK last week, where the Justice Secretary has been under pressure to resign if he can't reverse the plunging rape conviction rates. So they use the drop in conviction rates to argue more should be done to remove legal protections from accused men and make it easier for rape allegations to sail through into court based purely on the woman's version of events. And they seek new ways to criminalise normal sexual behaviour to promote a never-ending stream of rape victims and accused men. Speakman's new sexual consent laws are designed to do precisely that. It's blatant social engineering aimed at sending more men to jail. Speakman states emphatically that this is the purpose of the new consent laws, to respond to feminist lobbying, claiming the justice system is failing rape victims.
The Attorney General, Mr. Speakman, acknowledged the growing calls across the community for reforms to respond more effectively to the scourge of sexual violence in this country. We can send the message that survivors' calls for reform have been heard.
As Cunneen points out, this means Speakman has turned the whole criminal process on its ear. The criminal case is not about the complainant. The centre of the case is the person being charged. The complainant is just a witness like everybody else.
The criminal trial is, as I say, about the person who is charged. It's not meant to be it's not a social work forum or a psychology convention. It's not there to provide the complainant with some kind of solace or affirmation or tremendous triumph. It's not about the complainant. There may be other things about the complainant, but as one has to say to juries now as a defence counsel, it is very nice and a lovely kind thing to believe your child or your neighbour or your friend if he or she says that they've been sexually assaulted. That's a very good thing, believe them. But a jury has to act judicially. And a jury can't be, and it doesn't work if police get into courts and start talking about victims. The victim did this and the victim did that. The court is not about believing victims.
Our justice system is already firmly tilted against accused men, but now the gloves are off, and the senior legal officer for our state is making it abundantly clear that the perception of equal treatment before the law is no longer a priority. What matters to this craven politician seeking brownie points from the feminist lobby is to find new ways of selling out accused men's rights to a fair hearing. So he proudly announces a new system where any woman who's felt let down by a lover can turn round and allege she never gave that enthusiastic consent every inch of the way, and his freedom will depend on whether ordinary men and women of our juries choose to believe her rather than him. Listen to Cunneen.
It's the accused whose liberty is at stake in a criminal trial. It is he, generally he, who's been arrested and thrown into custody until bail can be sought, who's had his home raided and searched by police, and this is happening with sexual assault cases all the time, who's had to pledge his life savings or have his parents mortgage their house to get for legal fees, and whose life is on hold for 2 or 3 years. We are really blurring lines here, and men, all men, and mothers and sisters and friends of men ought to be very concerned, because what wasn't rape last year may be rape next year if the purpose of these reforms is simply to increase the numbers of people who are convicted of rape.
And that's the point. This has nothing to do with promoting justice. It's all to do with punishing men. This is happening on your watch. We need to get active. Write to New South Wales MPs, write to the Premier, get involved in online conversations. Spread the word that we want a justice system which delivers fair treatment for men and women, not a feminist show trial designed to destroy men.